SJC-13045, Commonwealth versus Michael Noguera.
Okay, Attorney Sultan, whenever you're ready.
Good morning, Madam Chief Justice, and may it please the court. I appreciate the court's scheduling a second oral argument in this case after remanding it for a further evidentiary hearing. The evidence presented at that hearing crystallized the issues raised by the defendant's new trial motion and further supports his claim for relief. As the court knows, Michael Noguera was convicted of first-degree murder and related offenses. It was undisputed at trial that Noguera killed Daniel Smith with a single gunshot in a wooded area of Easton on November 8th, 2016. Noguera and Smith were friends and traveling companions. They had traveled from Florida to Massachusetts in Smith's car earlier that fall, but it was an abusive relationship. Smith was controlling and violent towards Noguera. He threw away his psychiatric medication. He threatened him with a gun. And in the days prior to the killing, Smith kicked Noguera out of their hotel room and sent him a number of text messages threatening Noguera and Noguera's child. Noguera, who was not capable of living by himself, was afraid of Smith and told others that he feared Smith was coming after him. Now, shortly before the scheduled trial, defense counsel moved for a continuance based on what he perceived as a need for a mental health evaluation of his client. And the trial court agreed, continued the trial, and ordered an examination and report under Chapter 123, Section 15A. The trial court also, sua sponte, summonsed in Noguera's mental health records from the Suffolk County Jail, where he was being held, to assist the evaluator. Dr. Eric Brown filed his preliminary report with the court in April of 2019, which documented Noguera's lengthy history of mental illness, psychiatric hospitalizations, and psychiatric medication over a period of decades. We now know, however, that Dr. Brown was never told that the Suffolk records were available, and he was never provided those records and never reviewed those records.
But Dr. Brown was aware of the suicide attempt, right?
I'm sorry, Your Honor?
Dr. Brown was aware of the suicide attempt?
Well, Dr. Brown, who testified at the remand hearing, testified that he did not remember what records he was actually sent by trial counsel. He testified
But we have
that
a record of what was sent by trial counsel, right? Didn't trial counsel's
there is no record of what was sent by trial.
administrative assistant document
Well, we have
certain
there
documents
were
that
some
were
notes.
sent to Dr. Brown and to the other expert?
Not exactly, Your Honor. There's some handwritten notes which purport to be what institutions records were received from, but there was no. Dr. Brown did not remember what records he reviewed, and he specifically stated that he never reviewed the Suffolk County Jail records. He was shown the Hackensack University emergency hospitalization records from 2010, and even after being shown them, he had no recollection of whether or not he had seen those records.
And what was the motion judge, who was the trial judge's finding as to all of these records?
So the findings of the motion judge, who was also the trial judge, with respect to the 4 sets of records, are as follows. So the first set are the U.S. Army records. Never obtained. There's no military release in the file. They were never obtained, so they obviously were never reviewed by trial counsel, never reviewed by the expert. Second set, Noguera's Social Security disability records documenting his mental health disability going back to 1989. never requested, never obtained, no release in the file. So that's the second set.
Well, hold on. Some of those were obtained directly from the source who provided the medical treatment.
Okay, so out of this massive set of Social Security records, which I submitted after I obtained them post-conviction with no particular difficulty, there were within that set, there were some records of a Dr. Danishmand from, I think, 2011 or 2012, which documented Mr. Noguera's depression. Those were, so it's true that those were, and with respect to those, we presume that those were sent to Dr. Brown, and he reviewed those. But that's a tiny subset of 30 years of Social Security disability records, particularly where Noguera, in his letter to his lawyer, detailing all the hospitals he had been at for psychiatric treatment, said, get my Social Security disability records, and trial counsel never did so. And the fourth set, if I may, Your Honor, are the Suffolk County Jail records.
Okay, but before you leave the SSA records,
yeah,
the judge also finds that there were records obtained from the Lehigh Regional Medical Center, University Hospital in Newark, New Jersey, and St. Mary's Hospital, Passaic, New Jersey.
that there were records within the social.
That he reviewed subsidiary records from not only Dashaman, but those ones I just mentioned.
As I recall, Your Honor, the other records were medical records, and Dr. Brown testified that most of the records he reviewed were medical records, not mental health records, and he further
And the content of those records will be in the...
Sorry, Your Honor.
We'll have those. We can look at them.
Yes, Your Honor.
Okay.
If I just complete my answer to Justice Wetland's question. So the fourth set of the Suffolk County jail records, in his original findings before the remand, the trial judge had found that Dr. Brown had reviewed those records, and the Commonwealth, both in its brief and in its oral argument, prior oral argument, argued that Dr. Brown had reviewed those records. But after Dr. Brown testified that he didn't, the trial judge changed that finding and found, following the remand, that Dr. Brown had never reviewed those records. And those records were 18 months documenting a long history of mental illness, psychiatric hospitalizations, diagnoses, and psychotropic medication. Dr. Brown never saw those. So those are the four sets of materials that were available to trial counsel. When trial counsel, at trial, he didn't have them. And with respect to the Hackensack ones, Your Honor, and the Danishmand ones, whether he got them or not, it is undisputed that whatever he sent to Dr. Brown, this was from the testimony at the remand hearing, he never asked Brown for them back. He never got them back. He didn't have them before the trial. He didn't have them in the courtroom. So whether he sent a couple of those records to Dr. Brown or not, they were not available in the courtroom to use when he chose to elicit from his client.
Now, what did Dr. Brown testify to in terms of his conclusion after interviewing the defendant and reviewing the documents that he did get?
Dr. Brown testified, consistent with what he told trial counsel, that he did not see a basis for a defense of lack of criminal responsibility.
And was that the same opinion that trial counsel got from the first expert?
It's exactly the same opinion he got from Dr. Sala.
And did Dr. Brown, having reviewed the documents that he did get, whatever they were, suggest that they might be harmful to the defendant because they showed malingering? And based on his review, Dr. Brown could not conclude that the defendant lacked criminal responsibility.
Well, Dr. Brown was specifically asked those questions, Your Honor, and I would commend to Your Honor the transcript of what he said.
I think I did read the transcript, and in fact, the answers are that he said consistent with the first expert, that he could not, consistent with his professional obligations, conclude that the defendant lacked criminal responsibility and that the documents actually showed a potential argument for malingering.
That's not what he testified to, respectfully, Your Honor. He testified he saw nothing in the records that were damaging to Noguera. He saw nothing in the records that said anything about malingering.
So you're saying that the judge's conclusions in that regard and his findings are clear error?
To the extent that the judge said that Dr. Brown testified the record showed malingering, that would be clear error, Your Honor, because Dr. Brown was specifically asked that question when he was pushed by the judge with respect to that issue.
So what, just
Yes, Your Honor.
pulling back for a little bit, what is the claim on the motion for a new trial? That trial counsel, having gotten two opinions from experts saying I can't support lack of criminal responsibility, should have what?
Your Honor, I'm not arguing there should have been a lack of criminal responsibility.
Right, but he should have
I'm
done
arguing
what?
that, number one, counsel was negligent in not obtaining and having available to him these records, and number two, having been negligent, he put his client on the stand. Well, his client took the stand, and defense counsel elicited at the beginning of direct examination testimony from Noguera that he had a long-standing mental illness, diagnoses, multiple hospitalizations, and psychotropic medication. He argued that to the jury that those conditions impaired Noguera's judgment and negated his specific intent to kill. He successfully obtained an instruction from the trial judge that the jury could consider credible evidence of mental impairment, and he exposed his client, and we now know from the remand that he knew this was going to happen, to a cross-examination where the prosecutor asked Noguera, do you have any documents to corroborate your claim of long-standing mental illness? And Noguera had to say no, and Noguera agreed that such documents would exist.
Attorney Sultan, ma'am.
Yes, Your Honor.
Oh, sorry, go ahead.
Oh, thank you.
So I was going to say, sorry.
Go ahead, please.
If I understand your argument, what you're saying is the harm here, the prejudice here was not the loss of a defense of lack of criminal responsibility, but the harm of leaving his client's testimony regarding his mental health history unsupported by documentary evidence.
When he deliberately elicited it, when he injected that issue into the case, when he asked the jury to consider it, yet he basically hung his client out to dry because he exposed him deliberately, and he testified he thought he wasn't surprised by this cross, to a devastating attack on his credibility, which, number one, negated any effect of this mental impairment on the jury's consideration, and number two, totally undermined Noguera's credibility.
Okay, so the failure here was to allow his client to testify to this history?
Well, his client has a right to testify. The failure was in not getting these records, not having these records, and when his client took the stand, deliberately injecting this issue into the case when his client was going to be pummeled on cross because those records weren't there, they were available, they would have effectively rebutted this attack. Indeed, there were records of, Noguera testified he had last been hospitalized in 2010, which was, or he testified 6 or 8 years earlier before the crime, so that would have been 2008 to 2010. The Hackensack records were from a hospitalization in 2010. They would have totally corroborated Noguera's testimony, but trial counsel didn't have them, couldn't use them.
So let me ask you a question on failure to fully investigate as a basis for ineffective assistance. I'm familiar with case law where defense attorneys have made the decision on their own and said, seems fine to me. I think that's Ribeiro in some other cases. Can you direct me to the case law on a defense attorney sticking their toe in the mental health records, but not getting all of them, where we said it's ineffective assistance to not fully investigate. Where you know, in the hill you have is that he hired 2 experts, but I understand the experts can only do what they can do based upon what's obtained. So, given those parameters, what's your best case law on not fully investigating a mental health?
That's some investigation isn't
Some of it,
necessarily an adequate investigation.
Right.
I would say the best case, Your Honor, which actually comes quite close to this one, is Alvarez. In Alvarez, the defendant put on an expert. Dr. Katz testified to a lack of criminal responsibility, but defense counsel, so he did an investigation. He got an expert. He put an expert on the stand who supported that defense, but he hadn't gotten the defendant's records, so that Dr. Katz was pummeled on cross-examination by the prosecutor who had those records. And this court said there was no reason why defense counsel didn't have those records, and his failure to get those records and provide them to his expert deprived the defendant of a defense. And so that's the best case, Your Honor. And here, so I submit that defense counsel was negligent and then compounded the negligence. He didn't have to inject this issue into the case. Noguera testified that he killed Smith in self-defense. He could have just gone with that.
Yeah, but he shot him in the back of the head, which presents a problem for a self-defense.
Does present a big problem.
Right,
Yes.
so it might have been a strategic choice to say, well, I have some mental health issues, so that my reaction is a little different than the ordinary person's
It's
reaction.
a great strategic choice. It's all he had. But to present that effectively, you have to have the records. You can't just put the guy up there. He testified, remand hearing, that he anticipated this attack, and his strategy for dealing with it was to put the defendant on the stand and let him testify. That is manifesting unreasonable.
I know it's hand in glove, but he's making that determination and doing it in that manner because he can't get an expert to say what he wants him to say based upon the records.
He doesn't need an expert. He needs, it's fine. I mean, there are plenty of cases where this court has said you don't need an expert to put on a mental health.
No, I get that, but what I'm saying is in this case,
He
doesn't have Salah, he doesn't have...
He needs something. He needs records. He could have gotten these records. He could have had them in the courtroom.
You know, you had said before that my reading of the transcript was wrong, where the judge, the motion judge, trial judge erred, but let me just read you from his findings. He says, according to trial counsel, Dr. Brown also told him that there was information in the records that he did see that could raise an issue that your client was malingering.
That is what trial counsel said before
And so
the
if
remand.
he had decided to bring in the records, he had a known risk that the Commonwealth might find its own expert to conclude that the defendant was making it all up.
Well,
Would
number one,
that
you're-
have been a better strategic choice? Is that your point?
No, Your Honor. Number one, whatever trial counsel said about something about Dr. Brown, on remand, he did not say that, and Dr. Brown specifically did not say that. Dr. Brown said, didn't see anything about malingering, didn't see anything harmful.
But you're saying that the trial judge, that when I look at the transcript, I'm not going to find anything that supports the trial judge, motion judge's conclusion that trial counsel testified that Dr. Brown told him that the record suggested malingering.
He did testify to that, I think, pre-remand, as I recall, but the trial counsel couldn't testify where it came from. I mean, that's not good enough. Where are the records? You have to look at the records. And
So it's not good enough for him to rely on the expert, Dr. Brown, telling him that? He has to himself find the line item that suggests malingering?
He has to ask he couldn't specify any more details. He was trying to justify his failure to present the records. You can't justify your failure to present records that you've never looked at and you don't have. Dr. Brown testified there was nothing like that in the records. So Dr. Brown's testimony seems to me to be more important, and this fanciful idea that by putting in records that he didn't have and never got would somehow going to open the door, it's a fantasy. You can't make those are not strategic decisions unless you have the records. He didn't get them, he didn't have them, he exposed his client to withering cross-examination needlessly. It's ineffective assistance to counsel, and surely it satisfies the more generous standard under 33E, because the jury, with those records, could well have returned a verdict of less than first-degree murder.
What's the rule, if we decide this is ineffective assistance, what's the rule that goes out to the defense bar regarding summons in the records where you're going to be deemed ineffective? I know you're going to say it's not this, it's this case, but what's the rule as far as if there are 15 sets of records, you better get all 15, we're going to have an IAC claim, what's the...
Your Honor, this court has said, I think Your Honor has said, that you don't have to go down every rabbit hole.
Yeah, that's the rabbit hole case.
So that's clear, okay. Where you're going to inject a mental health issue into a case, you have to do what this court has called an adequate investigation. So the message is, in this case, these are the records that are readily available, 30 years of a psychiatric, Social Security disability, mental health emergency hospitalizations, a suicide attempt in the Army where he tried to hang himself and he turned blue, Suffolk County jail records that document a long history of psychiatric hospitalizations and diagnoses. Wherever you want to draw the line, that's not adequate. That's a great lesson to the trial bar. The trial bar needs to know you don't have to go down every rabbit hole, but you have to do an adequate investigation based on the facts and circumstances of your case, and I hope this court will reinforce that message.
Okay, thank you very much.
Thank you, Your Honor.
Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. If I could briefly bring this case back up to the 10,000-foot level. There are 2 days of text messages showing the defendant carefully premeditating the death of Daniel Smith in the way that it happened. That is the problem that Attorney Camera was faced with. He didn't make an opening. He didn't decide if the defendant was going to testify until the last minute. There's text messages. The defendant and his girlfriend decide that the defendant for her is going to build his house, which becomes clear as murdered the defendant. He tries to get the defendant, or the victim, he tries to get the victim to go into the woods with him one time where the victim doesn't because he's suspicious and he thinks the defendant will have people with him and set him up. He reinitiates contact with the victim and tells him, your mother wants us to fix this. I cried when you left.
We still have to, it may have been not the best defense, but it's his defense. So when we look at the Suffolk County records, for instance, is it your understanding that when we carefully go through the motion hearings and the like, that those records were not given to Brown or Salah?
I think that actually that it may be a point on which, so neither Dr. Brown nor Attorney Camera have a present memory of specifically what they saw. The defendant chooses to infer that as they didn't have any of it. There are records from Attorney Camera that his office got a lot of these records. The Suffolk records.
What did Judge Pasquale say about this issue on the Suffolk County records? What's his finding, the trial judge's finding?
I think he actually makes a finding in both directions, which is a little, I think they may both have supporting evidence.
Because I'm troubled by that because you don't have to go digging really deep into his military history and go back to Hackensack, New Jersey, when the Suffolk County jail is who houses him, and if they say he's psychiatric.
Well, they say that he says that he has all of these things. They say client reports, and they give him a bunch of medications, as Dr. Brown says.
Well, I mean, are they giving him antipsychotic medications?
Yes.
Okay, they're not giving him chiclets, right? They're giving him.
As Dr. Brown says, a lot of I believe in his testimony, a lot of hospitalizations, they sort of work with what they see right there and what the person tells them.
But you would think that the professionals at the Suffolk County medical would not give people Thorazine just because, right? Or whatever.
I mean, I don't want to get outside the record with people I know's experience of.
All right, well, whatever. But that was some. If you're going to ask your client on direct examination about mental history, whether you think it's a cockamamie story or not, don't you need the records where he's being housed?
Well, I think he was walking a very fine line. I mean, he knew he didn't want the Commonwealth seeing any of them, and we couldn't see them as long as he didn't introduce them for anything. He wanted to try to suggest that the defendant was not right in the head in some way that would explain what he did here. He couldn't rationally get to, I think, mental impairment because that chiefly goes to ability to premeditate, and the jury could see the documentary evidence of the defendant premeditating in some detail. So he has to essentially say, I mean, in his closing...
But the judge gave an instruction on mitigation, correct?
Yes. I mean, and there's also lots of drug and alcohol and substance, and Dr. Brown said that he thought that a lot of the defendant's diagnoses over the years could be partly attributed to the lack of ability of people to figure out whether it was a major mental illness or the substance abuse. Dr. Brown ultimately had a real problem with the defendant's theory of the defendant told him what he thought happened, and Dr. Brown, according to his testimony, thought it didn't make psychological sense and also didn't make rational sense. And he thought that it didn't really fit with with the defendant's claims of mental illness or with his claims of essentially self-defense, including that, I mean, for essentially the same reasons that the prosecutor's closing is full of the fact that the defendant's self-defense defense doesn't make a lot of sense. The one final piece of which was the medication, but most of which is just it doesn't fit with the other like documentary evidence that we have of what happened, including times, including videos, including texts, and that ultimately, sorry, I completely.
It's a different case because we have an experienced lawyer who consults with not one but with two experts, and they come out and say there's nothing here.
And the second,
but it's only as good as the information they have to base it on, right? As the investigation.
well, the judge ultimately finds that they had most of the underlying medical history. The Suffolk records are after the defendant has been incarcerated. He's facing charges. He makes comments about how he's hoping to reduce the charges. There's some suggestion he starts having auditory hallucinations after his trial date is scheduled, and that's when Attorney Camera says that he wants him examined. I mean, it's not, possibly you could draw different readings from that, but in terms of substantiating that independent of his legal interests, he has this history. You know, they have the other records.
Well, some of the records do, from being charged, make explicit reference to hallucinations, correct?
Yes, the 2010 records, which also I noted contain self-reporting from the defendant that contradict a key part of his defense, which is that he can't fight, so he has to do all of these passive things. He self-reports that under stress he hits and he kicks, and he may have gotten in a fight 2 weeks ago, and that essentially, there's a lot of stuff going on here that, again, that Attorney Camera, I think his big concern was he didn't want the Commonwealth to see it. He didn't want us to be able to do anything with it. He knew how hard-fought all of the evidentiary issues are here. His closing is essentially focused on,
But if you investigate and the Commonwealth gets the records, the way to keep the Commonwealth out of it is to not put the evidence on, correct?
Yes, I mean, I think...
Right, so then at the end, you're saying he wants to have his cake and eat it?
But he has like all of the information from most of the records, according to what the motion judge finds. He shows them to two experts, one of whom, on the defendant's self-reporting, is initially hopeful and then reviews more records and decides he can't do anything for him, and in Attorney Camera's recollection, thought he might be malingering. There's a variety of things in all of these records that wouldn't directly support what the defendant's saying, that he wouldn't want people... I mean, ultimately, in his closing, he acknowledges there's all these text messages, the Commonwealth's going to want to talk about them, but don't look there, look over here, look at the defendant and who he tells you he is and who he tells you Daniel Smith is. Which of these people is more likely to pull a gun on somebody in the woods? Never mind all the evidence that, in fact, it was the defendant shooting the victim in the back of the head.
What do we make of Attorney Camera's testimony in the motion hearing that he knew the hammer was going to come down when he asked the question? The defendant says, "I've got 30 years of psychiatric history," and then Attorney Camera says, "Well," and then the Commonwealth comes up and says, "That's great. Where are the records?"
Well, first of all, Attorney Camera, he says he thinks that he gets an instruction from the judge on the closing. The defense has no burden of production, and he said he thought that neutralized it. But I think he's taking a calculated risk that it is. And the motion judge makes the findings in both his first and second motion for new trial decisions. This was not ultimately about whether the defendant could substantiate his medical records. It's about all the evidence that he planned to shot the victim in the back of the head and demonstrated consciousness of guilt. That's ultimately where the game is at. That's what Attorney Camera is wrestling with. And he tries to sort of walk a very fine line, and he appears to, as a very experienced attorney, have been satisfied. I mean, he noted it didn't work. He said it was a hard case to defend, that ultimately he inferentially dislikes all of his other choices more. There is testimony that he didn't talk to the victim about whether to introduce his records. There's no testimony, or to the defendant, there's no testimony about the nature of their discussion of the self-defense, what the defendant wanted, what the defendant insisted had happened. I mean, again, to the extent that the defendant's own version of the facts cannot pass muster under self-defense without he's not right in the head. He's making weird choices. Even with that, if the jury really sort of hammers down on the logical requirements of it, there's going to be a problem. It has to go on the defendant speaking his truth, and we're going to go with that, and we like the vibes more on the defense side. He does not really have, when you drill down, he can't really back up the mental health claims. He can't really tie them to what the defendant did. He can't square that with the text messages, with all of the evidence of motive and premeditation. And he can't really explain how this makes sense as self-defense. And that's essentially the reaction he got from Dr. Brown after some hopeful beginnings about whether there could be potential things he could work with here. And he's shown these records to two experts who essentially said that there wasn't anything he could do for them. He really looks down
Would you agree with the general proposition that an attorney should not ask his client a question that would open him up to cross-examination that the lawyer could not then address on recross, which is essentially what happened here, right? You're contending that that's a legitimate strategic choice, or I think you just used the phrase calculated risk. Have we ever said anything like that, that lawyer can go ask questions that will open his client up to a cross-examination that then the lawyer cannot address or rebut on recross?
I mean, off the top of my head, I don't know, but I think that would go to the heart of being a strategic lawyer and having the information. And, the other choice is just not to put on any mental health elements and hope that somehow the defendant can account for his conduct, or the jury can account for the defendant's conduct in some other way. It wasn't great, but he didn't, he went down to the wire on deciding whether to call the defendant at all. He tried to establish some third-party culprit and various other reasonable doubt. It's his choice. It depends what his next good choice is and whether it's worse. He's got to work with what he has.
There's no downside, though, to getting the records, right?
Oh, you mean to producing them at trial and having the Commonwealth have them?
Well, no, the question was, do you have anything to back that up?
I mean, what he said was there was no way I was ever going to introduce them, so he didn't, and frankly, I don't know, but, if at that point, if somehow the Commonwealth argues he opens the doors and they want to see the records, I don't have the records, to the extent that he thought it was more important to keep them out of the Commonwealth's hands than it was to be able to produce them. Because again, frankly, this would have happened on a Friday. Then if the Commonwealth asks for further remedies, there's a little bit of time to do. There's all sorts of things that could follow from this, of various degrees of bad for his client, where the best case scenario is a cross-examination from the contents of the medical records, which frankly could cause additional problems.
So I don't recall in your brief any places where you specifically identified portions of the medical records that we now have that were so on their face problematic. Is the entire problem just based on the inference that that introducing the medical records would have prompted the Commonwealth to, get its own expert, et cetera? Or are you saying that the medical records themselves contain anything that they're so damaging to put them in front of the jury? Because I didn't see anything in them that rose to that level.
And it's in the motion judge's original motion for new trial findings, which he incorporates. He goes into some detail about reasons why counsel might not have wanted the jury or the Commonwealth to see each particular record. And I think...
But I'm asking what your position is. Is your position that
I incorporated that too.
So you think that the medical records, even apart from that, it was a reasonable strategic decision to want to keep these medical records away from the jury at any cost?
Again, I still don't know everything, but yes, I think it's certainly within the totality of what he knew, his additional conversations with the experts that no one may remember. But I think that, frankly, it substantiates that he's been telling people for years that he has things. I mean, it might be, it's sort of turtles all the way down. Like a lot of times they're like, well, assuming we take his word for it, this is, the situation. There's discussions in the Hackensack records that he keeps saying he's passively suicidal every time they're about to release him. There's various other, and again, it's possible the Commonwealth could have gotten an expert to say, when, as consistent with what Dr. Brown does say at later motion hearing somewhat, but that when you're in for a quick committal, they sort of try to address what they see in front of them and what you tell them, and they don't know most of what the other context is. And and there's not 30 years of him saying he's hearing voices. There's this one commitment, I think, in 2010, which has other issues with the records in terms of what the jury might make of it, including contradicting his sort of key thing that he has to act like this because he's passive.
When's the
and he
first
can't.
mental health diagnosis?
Sorry?
When's the first major mental health diagnosis
So
on the record?
in the Army records, I think they diagnosed him with depression and maybe borderline personality disorder. He specifically says schizoaffective goes back 30 years. And maybe there's a records, maybe he had a commitment somewhere that no one can get the record from now that would substantiate it, but Attorney Camera did not have any records that would substantiate that.
But the records do say schizoaffective, right, at some point? Recently.
And I don't know if that's diagnosis or self-report, because again, a lot of these are things he says he's been diagnosed with in the past. And so it's sort of, and I think even up to.
The Suffolk records do have a diagnosis though, right?
I don't know, I think a lot of it is client says. Almost everything they say, again, they looked at him. I'm sure that but Dr. Brown saying that this is a complicated thing. That it's not necessarily, when somebody, he also tells Suffolk that he hasn't drunk in 5 years, and drinking is a big part of his defense here. He's saying a lot of things to a lot of different people, and some of them may be true, but they don't paint a picture of somebody who is more credible as the result of having read those records. And they contradict other things he needs to explain. So Attorney Camera tried to get substantiation for battered person disorder, PTSD, that would explain why he is initiating contact with this person he's afraid of. He can't really explain the stated plan to kill him and have his phone within 24 hours, which he does, et cetera, and making plans for a getaway driver. But essentially, he needs to try to explain why the defendant does not react as a normal person would to supposedly, why he takes no opportunities to get away from the situation that he's supposedly terrified of. And, the records don't particularly substantiate any of that. He looked into it. Dr. Sella addresses, couldn't find PTSD, battered person syndrome. So he's, not every mental health issue also, weighs equally. And for those same reasons, I would argue not only was it reasonable strategic decision, it was no substantial likelihood of miscarriage of justice and no 33E. There's pretty overwhelming evidence that this was a premeditated murder, whatever else the participants had going on. Thank you, Your Honors.